Good morning, everyone. Thank you for joining us for this live webinar. With me, none other than Felicity and guest, a child maintenance activist. She's there to assist people and to fight for your rights when it comes to the rights of a minor child, especially when it comes to the issue of support maintenance. We all know maintenance is an important aspect in a child's life. Without maintenance, you can't eat, you can't live, and she is there to fight for that. Felicity, good morning. How are you doing?
Good morning, Mohammed. I'm good, thanks. How are you?
I am very, very well. The weather in Cape Town is cooler. It seems to be warmer that side. Last week we had a nice one. We were outside, and this today you're inside. Yes.
Yeah, well, there's a lawnmower going outside, so I'm inside.
Oh, okay. No, that's understandable. But Felicity, following up on what happened, what we discussed last week. Last week we discussed the aspect on how to apply for child maintenance. I'm gonna hold that video so long. If you want to watch that video again, please go to our previous videos. You will find it. Today I want to focus solely on the tools available, and nobody deals with this on the internet. The tools available to assist parties in obtaining the best possible maintenance result, which is important. For example, one tool be available is to go online on Facebook and see the person's details, how the person lives, copy it. But there are other tools available as well, doing financial inquiries, checks on the person, and so on. We know you offer those type of services. I want to discuss it. I want to apply my experience on those type of services and those tools, and let's educate our listeners.
Sure. Before we go into that, something that I've become quite aware of is there seems to be some, confusion as to how to fill in certain aspects of that form. For example, like the rent, because it appears that particularly when there are outstanding matters, that people are assisting, particularly the mothers, with paying certain bills, for example, like the rent. Where they're into like loan agreements whereby somebody else will pay the rent, or come into some kind of loose agreement that you can stay here, kind of house sit and contribute towards the living shared expenses. And not too sure how to fill that out in a way that it's not assumed that this person has access to all of this financial support and therefore doesn't need to get the full amount from the father. So I'd like to hear your opinion on that first, because I just say, it's best to be trying to be as transparent as possible, because if they establish that you're lying, then it's not going to hold you in good standing, because then they're going to start doubting everything that you fill in the form. So I suggest that whoever it is that is assisting you financially, to get some kind of affidavit or loan agreement or something in place so that you can submit that to show that you're actually going to have to pay this money back at some stage.
Yes, Felicity, regarding, I think maybe I should start from this point. The maintenance application form, people put too much focus on that. When the matter ultimately gets decided upon, the maintenance application form is just one document. Ultimately, the court will decide the matter on oral evidence, presentation of evidence, and so on. But at the same time, the maintenance application form has to be properly completed. When it comes to the issue concerning rent, let's say you're living with someone, you're not paying rent because you can't afford to pay that rent, but there should be an amount applicable. You'll have to pay that person somebody. Look at the form, complete whatever you can. Where it becomes like a problematic issue, for example, like rental, say, see attach annexure A, and explain, I'm not paying rent, but the person is entitled to have an amount of 500 Rand per month, therefore I want the other party to pay. So we shouldn't focus too much on the form itself is highly complicated in the sense of it's difficult to make sense of the real world onto a form. It's like saying every single animal there is in the world will have to be completed with 10 points. You can't do that. It's impossible. So when you deal with these maintenance application forms, I like saying, please see attached annexure A, annexure B, annexure C, to explain it. You still have your amounts at the bottom. So when the matter goes before the magistrate, ultimately, who makes the final decision on your matter, the application form is one part of your documentation. You still go on the witness stand. You still need to present everything. Therefore, even if the application form says your haircut is 50 rand, you still need to give all the evidence and stipulate it's 50 rand and show the court that it is 50 rand. Therefore, scratch a lot of things out in the maintenance application form. Put, for example, if something like that's outdated, for example, I don't say it's outdated. I do not know when last I purchased a newspaper. I don't know when last. So obviously I go online and I subscribe. Scratch the word newspaper out and put something else in there. Just so that things can make sense at the end of the day. I hope it makes sense to
Okay.
you, Felicity.
No, you absolutely do. You know, because another question that comes up is like, my child is not, you know, the things that should be paid that they can't because there is no money, that those amounts still need to be included with an explanation attached to it, as you say.
Yes, it's very important. So the maintenance application form, as we discussed last week, Felicity, it only has one column for a child. Some people have 4 or 5 children. That's the reality. People do have that amount of kids, and the father has to pay that. And they are different ages, and the expenses are different. The baby costs much, I'll say, different than the child that's 17 years old, that's at high school. How can you? And then the form becomes problematic because the mother is spending for the entire month, let's say, for argument's sake, 2,000 rand on groceries. I'm using a simple figure here, but she doesn't unpack it. Who eats more, who eats less, and who eats what? Because the baby only eats purity and it's very expensive. So what you do is you stipulate an amount, but you also say, maybe somewhere at the bottom, please see attached spreadsheet explaining all of the above. It makes life so much easier for the sole reason when the magistrate or the maintenance officer sits alone with the file before the hearing. Things make sense. The magistrate can start applying his or her mind to the case and get a holistic picture of it. And it also assists the other party, Felicity, to know where you're coming from, so you do not have to speak so much in the maintenance court. Your paperwork limits the amount of words you have to utter, and that causes less confrontation from happening.
Thank you for that. The other thing that seems to come up quite often while we're talking about that is that the exchange of bundles. Is there a legal requirement by when the bundles need to be exchanged by?
No, the Maintenance Act doesn't make reference to exchange of bundles and so on. Usually the parties will come to an agreement by the magistrate stipulating when they can exchange bundles. I would say a reasonable time to do so would be 1 week, because you have my bundles, I have your bundles. I can go through it in time. I can make my notes, my cross-referencing and so on in order for us to examine. The ideal situation would be, do not postpone the matter for a trial, stipulating that bundles should be given in a week before the trial date. Because what generally happens, and this is the reality, is on the trial date, bundles are not adequate, half the information requested are not provided. Therefore, what I would suggest is, at the first inquiry, you advise the parties, especially when they have legal representatives, please request from the other party the following documentation by this date, and make sure those specific documentation are provided by the following court date. So once you are back in the maintenance court, the maintenance officer can do like a case management. Are you happy with all the information? Are you happy? Are you not happy? If documentation are missing, the one party can explain why the documentation is missing. You can say, I went to the bank isn't willing to provide it for me, they'll charge 10,000 rand to give it to me. So the maintenance officer can make a decision or a ruling on that, or the magistrate. Then we are happy and we can proceed with the matter at the next appearance.
Yeah, because I found that is also quite a problem area, because the bundles are often exchanged on the morning of the trial, and there's not enough time to peruse them, and then the case is postponed again. And I mean, if you don't really, I mean, even you as a legal representative, you can only remind them. If they don't provide them, there's not much you can do to force them to give them to you on the due date. So, I mean, they can do, whoever is being a bit obstinate would just get chastised by the magistrate. But, you know, the reality is it just causes another postponement. But it's one of those things, you know, that's out of our control and we can't really do much about it.
Felicity, you were right on that. And on the topic of the bundle, a party can't just give a bundle. There must be a purpose behind the bundles, and every bundle will be different. Therefore, I always provide, when I deal with a matter, I will request from the other party formally a request for further documentation, further particulars, and so on. And I know this guy, he's self-employed, he's, for example, a taxi driver, he has this and that. So I will specifically request, I would like to know which organization are you part of, which association are you a member of, how much money do you make per month based upon this, because I have information, so I specifically request relevant information. I do not send a generic request for further information. Your bank statement for the last 3 years. I will say, I would like to have your bank statements for the last 3 years for this specific bank account, because I know that bank account. Um, so we are going to with this is, if you want to be successful with your case, have a plan, have a mission, and request. So if, Felicity, if the trial stages does occur, and this specific person did not provide a specific document, and it comes about that document is in existence, you can cross-examine him on that. Sir, I requested this from you. It is in existence. Why did you not provide it to me?
Okay. Thank you for that. I'm sure that will clear it up for some people, because the layperson gets thrown by these things because they feel kind of powerless to have any impact on it. Thank you.
You're welcome, Felicity.
Okay.
But let's go on to the other tools which I'm very excited to speak about. Let's deal with a general tool. One tool which we use often, and which the maintenance courts also use, doing a credit check on somebody. Maybe you can give your 2 cents. What are the benefits of doing a credit check from somebody? What can you pick up from a credit check? ITC check, TransUnion check, as the case may be. And I'll give some insight as well, and maybe I can add to what you have to say about it.
Sure, because what people, need to understand is that whenever somebody applies for credit, it's registered on the credit bureau. So, they might not have got it from that particular financial institution or whatever, but there's clearly an interest in purchasing, particularly when it's assets. But it means that there is this income that is potentially going to be spent somewhere, and Section 16(3)(c)(d) says that maintenance is a priority before debt, because debt can be rearranged. I mean, we know that. We see that with debt counseling, that, you go and renegotiate the debt, and you can't actually go to prison for debt. And maintenance is a priority payment after that. And that's something that comes up quite often in these hearings is, I've got too much debt, so I can't pay maintenance. And we are not hearing in these hearings, well, you need to go and reorganize your debt because your priority payment is maintenance. You can't be offering R1,000 maintenance, but you're paying 5,000 Rand on a motor car. I mean, it's just, but we're not seeing that as a general in the maintenance courts, because I don't know, somehow they've forgotten about that section of the Act and they don't really like to enforce it. And they don't really understand it, because when parents are going about maintenance of priority, this is what it says in Section 16(3)(b). I mean, the magistrates just go, well, everybody's got debt, kind of thing, so dismissive about it. But I mean, that means that the government has taken the priority of child support pretty seriously. So we need to just keep insisting that is adhered to. So that's where the credit checks are very important, because if somebody has got like 25,000 Rands worth of debt, well, just go and reorganize that. I mean, they have to go and renegotiate it somewhere to prioritize maintenance payments.
Felicity, adding to that,
the maintenance investigators, it has the mandate to do this investigation, but you said last week that it doesn't stop you as the applicant sourcing that information as well, because we see it a lot with people who are self-employed or hide their businesses in their new partners or family or friends' names. Yet, they're getting, it doesn't correlate with the bank statements somehow or the other. And then the court does have the ability to subpoena the person whose account or whose name the company is registered in, as well as the banks, for all of that information, who the bank accounts, whose name it is in with the bank. Because if somebody is hell-bent on hiding income, there are many ways to do it.
Felicity, I'll give my comment on the legal aspect of it and the tricks applicable. The sad part is, when somebody hides behind debt, it's sad, because He's saying, I have purchased every month a nice pair of jeans, clothing, etc., and now I have debt. And based upon me living a lavish life, I cannot now afford to pay the maintenance because this debt I've got myself into causes me to spend 2,000 rand per month as repayments. Therefore, the 2,000 rand per month should be deducted. But is the 2,000 rand per month was for luxury items, and why must the other party now all of a sudden spend more of his or her hard-earned money, although he or she earns much less than the other party? So I don't like this argument regarding debt and standing behind debt as a means of not paying child maintenance. That is totally nonsense. The nice thing about ITC checks, credit checks, and this is what I love about this. The moment you apply for credit somewhere, either for a car or for a home or for a home loan, whatever the case may be, it's recorded. It's recorded onto the check as well. So this father might come or the mother might come and say, I cannot afford to pay child maintenance, but you've applied 2 months ago at BMW for a new BMW with the entry level, it's most probably X amount of money. Why would you apply? And if you have applied to BMW for that specific car, there should be finance documentation applicable as well. What you have stated that you've earned. We go to BMW, we sell BMW, we subpoena from to BMW saying, please provide us with that application form. And it shows, then he can't say he's lying because then he committed, some type of criminal offense. And if he inflated it, I don't think he would say that. That is the type of information you can obtain from this. And with bank statements as well, but we'll get to bank statements in a minute's time. And you can give your input on that as first. So with credit agreements, with the ITC checks and so on, it doesn't advise you how much money the person has in the bank account. It doesn't do that. It only provides you with information as to what credit the person owes. For example, how much he owes on his house, how much he could potentially owe on credit, and so on. But that information becomes invaluable because it shows at a certain time in this person's life, 20 years ago, this person took out a loan of 50, 60, 70, 80,000 rand per month. What did he or she do with that money? It does show that this person living a lavish life or not living a lavish life, but it brings about very, very useful information to the court's attention, and it's objective information. It's not information thumbs up where the mother says no, he spends money on luxuries. It's documented information which he needs to explain. Unless he went for an operation or had to purchase something urgently, the ITC checks and the credit checks provides a lot of information.
Also, that we know with the reckless lending for credit providers, there's a certain income that you have to be earning in terms to get certain amounts of credit. And, yeah. So yes, it does. I mean, it is like a general assumption that if you're buying a motor car, that what the ratio is. I can't remember, but we can look it up and make that information available. Because if I'm not mistaken, you still have certain amount of disposable cash if you are applying for this kind of credit to protect consumers from reckless lending. So yeah, there are certain, although it doesn't appear obvious, there is certain conclusions that one can come to based on applications as well.
Felicity, you're right. I mean, I'm certain these credit providers, they would not have given the credit unless they'd done their own checks as well. So someone will be very, very disclosing. He will disclose all his forms of income to the bank and to the loan company, BMW, Volkswagen, whatever the case may be. He will do that. He might even inflate it. I do not know. But at the end of the day, it's relevant information that you can use in the art of cross-examination or in the form of cross-examination. This is what I'm saying. And Felicity, I'm changing my tone in the sense of how I'm advising people to deal with the maintenance matters. You need to own your maintenance case. You need to imagine yourself as a lawyer with your robe on, cross-examining the other party. You need to do that. You need to smash him to pieces. You need to do what you have to do. Watch Suits, watch these law movies, so that you can get the attitude and a bit of guts to go to the maintenance court with a mission and with a plan. You need to do that. And that's when we'll go to the results. Don't be afraid of asking him, sir, I'm looking through your bank statements. Why is the documentation missing? Where is that? But we'll deal with the bank statement later on. You need to be tough on yourself. And it's embarrassing sometimes when you find lawyers who are not so tough as well. You need to fight for your case. So if you're going to pay a lawyer X amount of money to fight for your case, you need to fight much harder than that specific lawyer. So Felicity, that was the first tool we dealt with, credit checks, which you can obviously assist people with. The second one, which I want us to touch on, and it's very exciting, bank statements. Any comments on that?
Yeah, it's for me again. We speak to different situations. If it's an ordinary person who's employed and gets a bank statement, well, those are pretty standard. Those are pretty easy to demand. But also, some people seem to interpret a bank statement just with the opening, the front part of the statement that says opening balance, closing balance, without all the detail, and they submit that. And then, of course, we know the other situation where people are self-employed, or they have a job and they have a side hustle and they have different bank accounts. But again, the maintenance court has the ability to subpoena these statements. They can subpoena every single bank and, request bank statements from every single bank. Yes, it does take a bit of time, but I mean, they have the tools to do that, because some people don't disclose they have a second bank account and certain monies go in there.
Felicity, there are many people who are extremely honest. There are many maintenance matters cases whereby the mother, I'll be honest with you, she exaggerates. The father truly can only afford that amount of money and is living a decent lifestyle. And there are many cases also where parties are now playing the system. They lie to the maintenance court, they lie to the other party because they do not want to pay more money, or one party wants to claim more money, although he or she is not entitled to that. The beautiful thing about bank statements for me, it gives a person a chronological life story of this person. So if you have bank statements for the last 3 years of anybody, you can find out how does this person live his life. Credit card statements are very, very useful as well. For example, this guy will say he can't afford mainly. The Mother Institute maintenance proceedings in January 2020. They appear in the maintenance court. The matter gets heard finally in a year later. Let's say it's a bad scenario. He said he can only afford 300 Rand maintenance. But his credit card statements and his bank statement shows money coming in, but he spends money on bars, on taverns, taverns. He spends money on restaurants, on flowers for the new girlfriend, coming to so much more than what he has to pay maintenance for. Cigarettes, gross entertainment, and so on. So it chronologically shows a person's lifestyle. So if you put on your lawyer's cap as a complainant, you go through this person's bank statements. Yes, the income is very easy to work out, salary comes in and so on. But his expenditure, he's doing credit card swiping at Grand West Casino, or he's buying stuff for 5,000 in cash, and then next day he does something else as well. Where does money go to? It shows a certain type of you can put it, the bottom line is you can elicit information from that specific bank statements that is extremely useful for cross-examination. Felicity, a maintenance inquiry is not based upon information you only present. That's very important to note. That's half the scenario. A successful maintenance inquiry is based also upon how you challenge the other party's evidence that is presented. I think we're focusing too much on these type of inquiries, just providing your income and expenditure and explaining your case. That's the one half. The other half is to challenge the father or the mother where they stipulate, I can only afford 500 Rand per month. You can afford 500 Rand per month, but why are you buying 2,000 Rand worth of booze per month? 500 Rand on flowers, hotel, whatever the facts are. Bank statements can assist you regarding that.
Yeah, no, absolutely. I mean, that's exactly what I say to the people that I coach, is I go, you need to start thinking how a legal representative would think and how they would interrogate. And interesting, one of my clients was in court this week, and she said to me, this attorney, so the respondent doesn't come to court, apparently because of COVID. However, he runs a restaurant and is always at the restaurant every day, but he can't come to court for risk of COVID, but interesting. So she said that this attorney's always been like sweet and, nice. And suddenly she was like cross-examining this attorney. And she said like he was horrible. he has never behaved like this before. And he started like really then turned the tables and started going, well, look at your statement. Look at this. You're spending this on this, and you need to stop spending money on that. So I said, well, he wasn't expecting you to be so informed. Because the other thing is I keep saying is, I mean, we don't, as lay people, don't really know the act as well as legal practitioners, particularly those that specialize. So I suggest take the Maintenance Act with you and highlight the parts that are pertinent to your case. that you can say, excuse me, but you seem to be deviating from what the Maintenance Act provides for. But the Maintenance Act, if you print it out, is a very valuable, talking about a tool, because if you, from the beginning, it explains the role of every single person along the value chain that you're going to encounter, their job spec, their qualifications, and that's valuable, because if that particular person, whether it's a clerk or the maintenance officer or whoever, is acting beyond their mandate or not acting within their mandate, then you have a right to question that. And we've mentioned this before, because we can't assume that the maintenance officer has a LLB or some equivalent legal qualification, because people are slipping into those positions who don't have the necessary qualifications. So it's not that we have to suddenly kind of get a mini law degree in the Maintenance Act, but it's part of a life tool as well. So whether it's maintenance, whether it's going to the Home Affairs Office, whether it's going to your bank, your store, or whatever, what you are learning is that within our Constitution, there's a Bill of Rights, and you have rights as a citizen of this country, that you've got rights. And when you understand, that's what you learn from this process. And you learn how to become empowered to actually stand up for your rights. Because like anything in life, I mean, if there's a free competition going, you can't stand a chance of winning the prize if you don't enter. You've got to participate. If you are just a spectator in life, you miss out a lot on life, and then you can't complain that things are not working for you. But if you become active and you become proactive, then you start taking a little bit, you take a lot of control, and you start having some kind of part in determining the outcome. And that's what it is with the Maintenance Act. For me, you're participating. It's a partnership. You go in there as informed as you are, as you can be. And if you're not, then you stop and you ask questions and become more informed. And that's how I believe, one way that we can start demanding a better service from service providers. And we are actually just clients of the maintenance process. And we need to demand a better service from our service provider. The fact that it's like a basic human right is like just gives us actually more power to have it enforced, because there's so many international agreements. I mean, and there's a focus, because children can't protect themselves.
Felicity, I like what you're saying, and I agree with you wholeheartedly. You need to have your tools, you need to know the law applicable, and the law applicable is the Maintenance Act. If you go to the Maintenance Court and attend to a maintenance matter without having looked at the Maintenance Act, don't believe that I'm not a lawyer, I'm not an attorney. The Maintenance Act is a simple piece of legislation. At least go through it a few times. If you do not understand it, there are many articles online that explains the Maintenance Act. And at the same time, there's a lot of case law where high courts have dealt with maintenance appeals. They don't deal with maintenance matters in the first instance, but they have dealt with maintenance appeals, and they've explained the maintenance court made a balls up, they made a mess up, or the maintenance officer done it, whatever the case may be, or the parties they did not present evidence correctly, and this is how maintenance should work and how it does work. Like this one appeal I done last year or the year before in Pietermaritzburg, Port Elizabeth, whereby the High Court said there's obligation upon the maintenance officers to do their jobs, and the maintenance investigators to do their jobs, and the maintenance magistrates to do their jobs. They have a legal obligation. They cannot, if a maintenance magistrate attends to a hearing and half the documentation is not there, he cannot hear the matter. But they do still hear the matters, but he cannot. And if you know the law, you go online, you Google it, there's so much websites available, and it's presented to the magistrate and say, Magistrate, this is the law, my understanding of the law. He said, what can he say? He cannot dispute it because it was a higher court that made that specific ruling, and he's bound by that specific ruling.
Sure, and there's also there's two constitutional cases that also go into it in detail, and one is as early as 2003, where they categorically state that these maintenance cases, one should never go to high court, because a maintenance court is established specifically to specialize in this. So it's only in extreme cases, or with the other aspects of the law, then it should. And I mean, this comes from the Concord. And as I say, the one precedent that I'm aware of is 2003, and then there's another one. As soon as I have more time, I do put precedents up from time to time because they are very helpful. But I will develop a collection of them and put them on files on the group so that people can easily reference them. Because I mean, and we can see it like from people watching these kind of things, as well as on the group, that people are becoming more informed and they want to be better equipped. They want a better toolbox to navigate this.
And it's important that if you know the law, and you don't have to be an expert, an advocate, or an attorney. You understand the law. You apply the mind to it. You watch webinars. You read articles. You will be so much more confident in the system. You honestly, your results will be much better than someone who is not informed and not educated. And that's something which is important to know.
I just had a thought, Mohammed.
Share it, Felicity.
We should do a mock maintenance court case application. And you can act like the prosecutor, or we can get somebody else to act like the prosecutor and a magistrate, just to give people who haven't applied before a kind of idea of what to expect. That could be quite fun. Think about it.
No, Felicity, I like the idea very much, and maybe it can assist people with their confidence. And see how easy the process is, how presenting your information, being cross-examined and cross-examining the other party, because at the end of the day, that's all that it entails. Present your information, other party will challenge your information, which they're entitled to do, and you will allow the other party to present his or her information, and you will challenge that. That's it. So we should maybe do that, Felicity. Get some people on board, and we can do a live Zoom webinar where that is concerned. And people can.
No, I think that would be amazing. It could also be a teaching tool to the DOJ. Maybe they find it helpful and they use it to educate their staff as well. Yay! We can wish.
I love it, Felicity, and I think I'm available. I don't know what I'll be. I think I'll just have to be the magistrate. That's easier, do less work. Just listen and watch.
Yes. Mohammed.
You guys
hierarchy of dominance, I see.
Yes, I'll sit there and just look at each one of you and make a ruling at the end of the day. No, but I like the idea. I like the idea. So Felicity, let's move on. You're gonna another. Oh, this time flew now. We're now 30 minutes, 32 minutes live. The other issue, what other tools are there? Now, I like making use of social media as a tool, because social media at the same time gives a big, historical lifestyle of the specific person, and it does do that. If the person is not on social media, fine, but one of his friends might be on social media and tags him in a picture, although he doesn't have an account. You need to be creative. You need to be like the FBI, the CIA. You need to think on that basis. So therefore, if the father is saying, I do not go out, why is this Instagram post, why is this Facebook post showing that every weekend he has a different item of clothing on, and you've documented it, and every weekend he's at a different restaurant eating and enjoying himself? Very relevant information. You might say, but that's not evidence. It is evidence. You can put it to that person, and it affects the person's credibility, because this person is living a good life, enjoying his life, but here you have to struggle supporting your minor child who cannot afford Kentucky or Nando's, whatever the case may be, but he's at expensive restaurants as such. Social media, a big plus. If he has friends, find out. If he does not have an account, find out who his friends are and play the game.
Absolutely, because as you said, and I just want to also say this, that you need to create a history. If you just take one isolated picture and go, well, look at this, we all know that these, you can't assume that because there's one picture that he's sitting in a car, that it's his car, or, that because there's a photo of him having an expensive bottle of wine in an expensive restaurant, that this is what he does continuously. It might be a birthday or somebody else has paid for it. So create a history of a lifestyle that you're trying to prove that contradicts what they're submitting, and preferably from more than one source on social media, as you say, Instagram. And often, if you Google somebody, often their names, their pictures pop up without and just go through there. You'll be surprised what Google shows.
we invite everyone to Google me and you and Felicity. There's a lot of articles and data which we have provided, which you can watch. But Felicity, on the same on that note, then you don't put on your lawyer's hat. You put on your journalistic hat on you. I mean, people are quickly to find out dirt from other people. So go do your research. Go to an internet cafe that doesn't charge that much money, and go and do your use of data and find out the information. Felicity, one aspect or one tool that's very relevant, LinkedIn. LinkedIn is very interesting because on LinkedIn, somebody, a professional person, would outline his work history, who he is, and so on. That data can be extremely useful. Many times, people do not want to advise the other party where he is working or was working, currently working, and so on. So do that. There are so many tools that can be used in the court realm, which you do not much have to argue. You can just present it in your bundle of documentation. They'll have to answer it. Maybe half the time it's irrelevant, but it's half the time as opposed to zero of the time. That's where I'm going to with this.
Yeah, good point.
So Felicity, any final notes? Yes, let's get to the main thing. If I have, oh, we have a nice comment. The person says, "Love the energy of Felicity." Very, very good comment there. Felicity, you have a lot of energy, which is good. And I admire that about you. And especially with these type of webinars, Felicity, the reality of the matter is our jobs and your job as well. Law, it's not sort of, like the movies, going to court, 1, 2, 3. The court episode might be 10 minutes, but the preparation and the boarding hours and the sitting down and putting out your hair, I have no hair left, is seriously the hundreds of hours, whereby the sexy hours are the ultimate hours for a few hours. Where I'm going to with this over here is you need to be positive. You need to stop being gloomy. You need to be on a mission here. My mission here is forget about emotions. Yes, he abused me. Yes, he swore at me. Yes, he had an affair with somebody. That's fine. But I am on a mission here. My mission here is to receive child maintenance. And I'm opening up my docket, my portfolio, etc. And I'm going to work on this. And I will be successful for the sole reason because he can afford it and I have the information to do so. But don't sit back and feel sorry for yourself and hope that the maintenance court will find in your favor. How can you expect a maintenance officer who must be neutral, generally neutral, to cross-examine the other party? Like he should be cross-examined. He won't do that. He'll ask relevant questions, but that's it. You can do that. You can challenge the other party and present evidence, and obviously the court will be swayed by that.
Yeah, so I would just like to reframe how you started, and I'd like to reframe it in this way. You probably have every reason to be angry and bitter, and there's a history of different forms of abuse. Channel that. Channel it. Channel it into becoming more empowered, becoming more informed, because we're doing it for our children, but we're also doing it for ourselves. One, besides learning how to take our power back, we are also doing it because it relieves us of some financial stress, some emotional stress, so that we do benefit as the person who is trying to have the child's rights upheld. So I say, channel it, and on the day, there is no place in the court of law for emotions. They just want facts. So channel it into your kundalini, your energy inside, and that become detached from the person that you are seeing there, that it could be a stranger, and that you are going through a process, and mentally to prepare for that, because you can then disassociate with the memories and the triggers of that person, and you can stay focused. Because one of the tactics, especially if there's like a very experienced legal person representing them who is their barrier, is to intimidate you, so that you become easy to manipulate, so that their client can get what they want out of it. If you emotionally, if you have an emotional equilibrium, and you're aware that these are possible tactics, when they happen, you see them for what they are. You don't take it personally. In your head, you take a deep breath, and it gives you time to focus again on the point, to ignore that stuff on the outside, because it's just noise. It's just part of the game. So I say to my ladies or my clients, I have the occasional men, is just imagine this like a game of chess. Okay, there are opposing sides, and you have to have a strategy, and the strategy is all encompassing. And what is the biggest asset in a game of chess is patience and anticipating your opposition's next move. And that's what, if you view this similar, you become a lot more able to see it for what it is, see it in perspective, and to just stay in an equilibrium that doesn't throw you. Because, you know, then you go home and you've got a stomach ache and you've got a tension headache. Yes, those things happen. But the other part of our toolbox is being mentally, emotionally, and psychologically ready, because for some people, these are very traumatizing experiences.
Felicity, well said. Thank you very much for that. A maintenance inquiry could be your opportunity to get back to the other party. Indirectly, I'm not encouraging it, but let's say you were abused by this person. You know, whenever you open your mouth, the other person tell you to keep quiet in a rude fashion, and they can't get your point across. If you are doing your own maintenance inquiry, either you're your attorney, but if you're doing your own one, you can put to the other party, "Sir, you are lying. You have not incurred those expenditures." And he must look you in the eye and he must answer, he must be respectful to you, and he has to deal with those specific things. Whereby, before the maintenance inquiry has taken place, you are not allowed to do that. You are limited because the other person would either swear at you or be rude back at you. But in the maintenance inquiry, this is a place whereby you can deal with this person, and this person will have to respond properly and respectfully towards you. Felicity, we have another live comment. It says the following: "I love these webinars very much. Keep up with a good job. You guys are really motivating us who needs to fight for our children's rights." Felicity, awesome. Thank you for that comment. And as to the our jobs are not here to we're here to, as you know, we're here to assist people. And by doing a webinar like this, if we can reach as much people as possible and motivate them to fight for their rights, then we are extremely happy. I can go back, I can go home, I can rest, and I can feel, okay, finally someone is benefiting from this. So thank you very much for the comments, and you're welcome to post any further. We have another comment over here. Felicity, I think I can deal with that after you've answered one question for me. Felicity, how do we get hold of you? I see your website, I see your Facebook page, Child Maintenance Difficulties South Africa. Your email address is on screen, felicity.cmdsa@gmail.com. If I want to engage in your services, because you know these things, to assist me in my toolbox. Currently, my toolbox is only, he owes me maintenance and maybe some receipts. Part of my toolbox must be a well-prepared maintenance application form, an ITC check, whatever documentation I can get, some physical walking to various places based upon the client's requirements. How do I engage with you when it comes to requiring your coaching and your assistance?
Some people inbox me on Facebook, and some email me directly. Once I have engaged either way, then I'll explain what my services are and how much they cost, and it really is quite reasonable. It's a in my opinion, a small fee of 400 Rand that is worth 100 times the money spent. And as soon as I have proof of payment, then I set up an appointment over WhatsApp phone call, because then I'm able to have a quick look at the maintenance application forms or whatever the documents that they have. I'm able to peruse through them, and then we can have a WhatsApp conversation. And those depend, some of them are 20 minutes, some of them are an hour and a half, depending on the nuances for each case. And then also thereafter, like the morning before court, I will, if I remember, I'll go, just sending you good luck for the court, and give me feedback how it went. And if there's a postponement, then, just before the next case, then we just go through and make sure that you're ready again. So for a small fee of 400 Rand, it's very valuable, because I'm not a psychiatrist, I'm not a legal person, but with 10 years experience as well as, analyzing the behavior on the group, which is nearly will be 7 years old in July. I have a fair amount of knowledge, understanding, insight, and also the copious amounts of research that I've done and my own research that I've now prepared. It's offering support and guidelines and sharing my experience and collective experience from so many hundreds of people who are going through this process. And it doesn't mean to say that you're going to go into your case and you're going to win, because my philosophy in life is I'm going to help you. I'm going to show you the tools that you need to go and fish. And you are going to go fish. I'm going to teach you how to fish, but you need to go and fish. There's no benefit. I know how to fish. Well, I always learn how to catch different fish or different methods. So that's it. You need to go and learn to catch fish, and that's what will help you. If you didn't do that well and you lost your nerve, there's always another time. You come back, you reassess, and you work on it. It doesn't mean to say that you've lost or you failed. And whatever progress you make, a win is a win. And you build on those wins, whether it's a confidence or money, or that the maintenance officer heard you this time and they didn't before because your attitude has changed. A win is a win. And progress is progress.
Felicity, also at the same time, many times I contact you for some advice on some matters I am attending to, and you contact me for advice on some matters you are doing. So this is a cross-pollination of ideas, because none of us know all the information, but if we have the resources available, you have a huge set of resources available regarding your group, because you are from the ground level, you're obtaining all the problems and you know what's happening. You know the trends. I might not know the trends, but I might know the laws, and you can benefit from that, and vice versa. Felicity, thank you for that. Another comment says, thanks so much for all the information. Really appreciate it. You are welcome. Felicity, we have one question, last question before we end off. It says the following: I have applied for child maintenance from May last year and was given the run around till I got fed up with the local court and had to take my matter to the chief magistrate. Then on the order, so then only the order was made. Ever since then, I never received one payment, and it's been a year now. Okay, that's the way I read it. So basically, the order was made a year ago and he never received any payment. The quick answer to that is you need to approach a maintenance court again and lay a complaint for non-compliance with the maintenance order. It is a criminal offence. Alternatively, they can follow the civil route and they can attach a person's property, but you need to go to the maintenance court. That is the first step. I can't advise anything else. Anything you want to comment upon, Felicity?
Yeah, I just want to say that, don't leave it too long. As soon as a person falls into arrears, whether they haven't paid school fees, a portion of the maintenance agreement, or in totality, approach the court ASAP, because something you've got to take into account is the time period before that person appears in court. And if you're going to wait 4 months before you do anything, it could be pretty close to a year before you even get to hear. And we see this. What happens then, it becomes more difficult if people don't have pensions and whatever to attach bigger amounts. It becomes more difficult to get a lump sum for arrears. And then they divide it up to 150 Rand a month. So approach the courts ASAP. As soon as a person defaults, I think the law gives you 7 working days. So it's 10 days. Go to court and implement the process immediately. Don't wait. Don't take it personally. It's, this is also where, this whole emotional thing, because then the other party says, no, let's not take it to court. Let's just keep this between us. There's no space for this, okay? It's just, let's just do this. Simple, no emotions. It's not because I don't trust you, don't like you, or whatever. This is the best for us and for the children, because it almost becomes, it takes away that emotional manipulation and coercion, or the space for it. It still happens, but it diminishes the ability for that.
Thank you very much for that, Felicity. That's our time. It's now 48 minutes. I'm recording these videos because it has to go up somewhere else later on. Thank you very much for your time, Felicity. It was very exciting. We spoke out of the box. We spoke creatively. A lot of tricks that were up our sleeves that many legal practitioners do not know about as well. Hopefully they can benefit from it as well. And next week we'll have something more exciting for our viewers, and I'm looking forward to that one. Felicity, just stay on the line. Let me end this video quickly via the streams, and I'll chat to you in a minute's time. Thank you. Thank you, all the viewers.
Okay, bye-bye. Thank you.